What it do, man? It's your boy Battle Truth coming to you live and direct from the Battle Truth headquarters. Let's get right off into this. So last week, Unbias' house was hit by the U.S. Marshals as they raided his mother's house on a warrant that was signed off by the judge to get DNA samples from his mouth. I put up that paperwork and everything because apparently they are proceeding with the trial. Now, for a minute, he has been lying to the battle rap community, had them believing that his charges was dropped and that he not going back to court and that the judge just told him, I don't ever want to see you again after releasing him, when we clearly let it be known what was the reason for his release. He was on he was on $140,000 bond, property bond. So some relatives of his put up property for his body. That's what they tend to do. Same thing Puffy trying to do right now to get out of prison. He want to put up $50 million in property, in exchange for his body to be released. So this is the same thing that happened to Unbias. Relatives of his put up $140,000 of property it is for his bond as a result of them not charging him for the indictment in time. So as a result of him not being charged in time for the indictment, the judge gave him a bond. Now, sit right there, baby. Sit right there while I record. Matter of fact, come here. So as a result of that, they ended up releasing him and put him under house arrest for a year. So while he was on house arrest for a year, paying on his house arrest, his lawyers then put in another motion for him to work after he did a whole year without getting into any trouble or incident. That's how come you see him now when he's doing his blogs. He like, oh, I'm in this city, I'm in that city, I'm in this city. Because when they put the motion in on good faith that him actually happened to make money to earn a living, the judge never signed off on it and allowed him to work on a bracelet where he will always be monitored. So he's on a bracelet being monitored. Okay, that's why he won't show y'all his legs. Tell him to show you his legs. So he has a bracelet on his legs that monitor him everywhere he go, So with that being said, so people was asking questions. What you mean he on an appeal? I thought you only get an appeal when you've been found convicted or something. How is he on an appeal if he ain't been found convicted? Well, that's a different type of appeal. The appeal that he's on right now is the appeal for the evidence that will be allowed in his upcoming trial. That's what this court procedure is about right here. I'm about to play y'all. This is his live. This was a live recording of his court proceedings, arguing the very question y'all been asking me in the comments. What appeal? What appeal is he on when he hadn't been convicted yet? So the appeal is that you finna hear the argument. I'm gonna tell it to you, then you're gonna hear what they arguing. That man you see right there, that's Chris' lawyer. Down at the bottom right-hand side of the screen, that is Chris' lawyer, okay? And this is the appellate court. When you see those three judges up there, that's the appellate court that they are appealing as a result of the evidence that will be used in his upcoming trial. So what's happening is, when they raided Chris' house and got the warrant for Chris' house, some of the evidence that was took out the house, attaching him to some of the victims, some of the evidence was thrown out as a result of the detective going to T-Mobile saying that Chris was a serial rapist. This hadn't been said about him yet, which made what they are arguing, T-Mobile, give the GPS hit on where he was located since they only had the phone number. So from the phone number they had of Chris that was linked to T-Mobile, the detective went to T-Mobile to get a location on where that number can be found. And once they put a ping on it and a GPS signal hit on it, they was able to locate where Chris was residing at. Then from there, they went and go get a warrant to go inside. And this is what Chris and them lawyers is arguing, because apparently they were supposed to went and got a warrant for the judge to even go talk to T-Mobile. But the detective didn't do that, because the detective went on another argument they're going to be arguing, is the good faith argument, by which you have a mass serial rapist on the loose. And as a result of you trying to prevent somebody else from being raped, because he just raped 2 women back to back, less than 24 hours of one another. Because remember, they have different branches and law authority depending on what the crime is. Like if somebody get killed, what branch come out? The homicide branch. If you got robbery, burglary, what comes out? The unit that specializes in burglary. The burglary authority come out. Somebody get raped, who come out on them? The rape authority come out to investigate the rapes. Depending on what the nature of the crime, that special unit come out who's trained and experienced in those fields to actually professionally try to get those matters resolved. So when the one girl was raped on that Friday night, then the other girl was raped Saturday night within 24 hours of one another. Both the same rape unit came out. So when Kiera was raped on Friday, the rape unit came out, got all the information and everything. Then when another girl was raped that Saturday evening, the same rape unit came out. Same rape unit. And then when they got their information, they're like, hold on, this is the same details that the one girl gave yesterday. The same detail, the same description and everything. And they didn't even know each other. So the detective acted on good faith, and she felt as a police officer that they are dealing with a serial rapist who on the loose. And this is what Chris lawyer and them trying to argue. You're gonna hear the judge talking about it too, like y'all trying to get off on a technicality, even though Chris lawyer know that he's guilty of what he did. So with no further ado, I'm gonna let y'all hear, because again, people be acting like they don't get stuff, they don't understand stuff. But all the evidence is out here. Like I said, we have given you all the evidence. We have bought it for. So people, y'all don't have to make up excuses to justify whether or not. I mean, people, y'all ain't got to make up excuses to justify whether or not you want to watch them or not. If that's what you're going to do, then that's what you're going to do. You got to make up no excuse for it. So, and that's what I find out people be wanting to do. People know what the truth is. People understand what happens. They just want to have an excuse to actually justify still supporting the person, because they just don't care. But it don't really matter. I don't care if you support them or not. I'm going to put this truth out here and bring this stuff out here like this. So anything you say, that stuff don't mean nothing. So with that being said, with no further ado, here we go. Look at his lawyer. He got one of them rat lawyers. You know, it's just something about this lawyer, man, that just give me the scum vibes. Look at his suit and look at the tie that go with his suit. It's real cheesy, man. It's real cheesy.
Is bad. The answer to that is yes. Everything hinges on the real-time data that was procured from T-Mobile as a result of this exigent circumstances request.
Do you agree with the prosecution though that now we can ignore the writing itself as long as there were objective facts that would have supported it had this officer written it appropriately?
No, Your Honor. Then the two reasons why. The first reason is that Franks has been extended outside of the context of a search warrant affidavit. While there is no Georgia precedent expressly extending it to an exigent circumstance request, courts have extended it to other statutory circumstances like a wiretap application. And so the point of Franks is to give the defendant the opportunity to challenge the credibility of statements that were proffered to a recipient that he at the time could not cross-examine or develop further. And that's exactly what we're doing here. Secondly, even if we were to go past the language of the exigent circumstances request, the state's position still fails because factually, the facts known to Detective Evans gave her significant reasons to doubt that these two allegations were related. And on page 16 of our responsive brief in 1444, we lay out a litany. I think it's 10 or 12 objective circumstances of which she was aware prior to her submission of the ECR that showed compellingly that she had reasons to doubt these allegations. And I think that's the key.
I know there were differences in the circumstances, but they were kind of close in time, and you've got a similar vehicle and seemingly a similar individual being described as committing either an attempted rape or a rape and some type of a sexual assault, even if the conduct wasn't exactly the same. So does it, even if there were distinctions as to Craigslist or how they found, the one that was met at the bar, you still have somebody potentially committing two crimes within the same person committing it within a short period of time is one way to look at it.
Close in time, yes. Same vehicle, no. A very key important part of this is the interview of Michael Rucker, who was the third-party independent witness who observed Karen Hill, victim number 2, exit the vehicle as it was stopped outside his home. The interview of Michael Rucker shows that Detective Evans specifically asked Mr. Rucker, did this vehicle have distinctive rims? She's asking that question because in the interview with Simeon, alleged victim 1, that was one of the key identifying facts, was the car had distinctive rims. The car had distinctive rims. Detective Evans asked that question because she was predisposed to look for that fact from Simeon. Mr. Rucker's response, the sober witness in this situation, is no, it did not have distinctive rims. So this is a fact that does not corroborate her suspicion that these two acts are related. And then
but you're still talking about, people's recollections of things. We talk about witnesses all the time. Somebody might see somebody and think it's brown hair. The other one said, no, it's red. But it turns out it's the same person. Their perceptions of things are different. So whether someone thinks rims, if you're talking about a big black SUV, you can nitpick all those things, but isn't there sort of generally the idea that within a short period of time in a location where two women get, accosted sexually in ways that might be enough?
Yeah, right. Just like I'm saying. So according to Chris Lawyer, he just told on his client again. He said 2 rapes, yes, but 2 different vehicles. 2 rapes, but 2 different vehicles. In other words, my client might have raped 1, but he didn't rape 2 because they said the other truck had rims on it. It's the identical same truck, but one had rims. And my client didn't have rims on his truck. So yes, Your Honor, 2 rapes, but 2 different vehicles. 2 rapes, 2 different vehicles. We'll own up to one of the rapes, but somebody else is guilty of the other rape that got the rims on it. Like this man ain't raped the person, then changed the rims the next day to make the car look different. Like, come on, man. Come on, man. let's just keep it real. Come on now. Terrible. Just that simple like that. So it ain't no way to get around this stuff, bro. They finna hang that dude in that courtroom. Bro, you fighting a rape case. 3 women, Shannon, Karen, Kiara. 3 women, 3 different times. The judge is a woman. The DA is a woman. The lead detective is a woman. And the majority of your jury gonna be made up of women. Man, they finna light you up in that damn courtroom. They finna light that. They finna light that man up in that damn courtroom. Then he said, reasonable doubt. Let me tell you what hurt your reasonable doubt, Quinn. The reasonable doubt is this. Ain't no reasonable doubt when they got his DNA. They got your DNA with these women. You left DNA with Shannon. You left your DNA with Kiara. So they got DNA with you. Ain't no damn reasonable doubt. You're not going to beat DNA. Now, whether or not they allow some of the evidence in or not, that's one evidence they not throwing out. They ain't throwing out that DNA evidence. They can't throw out that DNA evidence. You can throw out a cell phone. But I don't really need the cell phone to put you at the scene of the crime. Your DNA put you at the scene of the crime, seeing that we don't know who the hell you is. So how did I magically get your DNA when I don't know who the hell you is? How I get your sperm? Like a damn sucker bitch at night. How I get your damn sperm? So I don't need the cell phone. So, okay, throw out the cell phone. Okay, throw out the cell phone. Throw out the cell phone record of your GPS location. Okay, now you have to explain how you don't know these women, and yet your DNA was found in them. So either way it go, you're done. Either way it go, you're done. The brothers say, so if he beat it, do it mean he's not guilty? It means he's not guilty in court, but that don't mean he ain't guilty in real life. You could beat plenty cases off technicalities. Don't mean that you wasn't guilty. Ain't that what they were saying what King Von had did? He had beat all the murders, even though he was guilty of the murders. But he had beat all the murders, but he actually did it. Ain't that the same thing of how Boosie got off? Boosie on record admitting he put bags on people's head, but then he beat it in court. So that don't mean, look, OJ, he killed Nicole now, but he got off on technicality. So it don't mean because you beat it, you not guilty. You could be not guilty in court, but still guilty of what you did. I'm gonna give you another example. Look at how many laws we break. How many laws we break every day we never really was arrested for? Do that mean we not guilty of what we did? Absolutely not. I ain't been arrested for it, but I definitely did it. See what I'm saying? It's stuff like that. Bro said King Von had someone else take the charge. Of all the killings? Of all the killings or just one? Of all the killings or just one? Quentin Davis said, I think he is, but in court, these things matter. Yeah, in court, they definitely do matter. But let's just look at this. Let's examine this. You got 6 felony rapes. 6. You're a black man. 6 felony rapes on black women. So this ain't a white and black thing like he tried to make it seem. It's a black thing. He black. All his rape victims is black too. The head detective is black. So it ain't a black and white thing. It's a right and wrong thing. right? So you a black man with 6 felony rape charges on you. What's the chances of you thinking they finna dismiss 6 felony rape charges on you? And that's why that judge lady was saying to him, like, you think we finna drop these charges off a technicality? Hold on, wait. What they say right here to them? Isn't that this?
Not standing alone, because you have to believe that she believes that these two allegations are linked. If she has reasons to doubt that they are linked, then there's no exigency. And so that's the key with this, is that
that the officer herself has to have no doubt. I mean, how is that ever to never have any doubt when you're doing your job in this circumstance?
Not that she has to have no doubt, but if the objective circumstances available to the officer at the time that she submits this request support substantial reasons for her to doubt her own statements that she's submitting to the provider, then objectively an exigent circumstance does not exist. And there was plenty of that. She stated that she had identified Ms. Simeon on a known pandering website prior to submitting this request. She had taken Ms. Simeon in a vehicle back to the crime scene where this had happened. Ms. Simeon, in her interview, told the detective that this act occurred in the middle of the street. They go back to the abandoned house and they find her sandal 100 yards up in this driveway. The detective is asking her, how did this happen? How can you explain your sandal got here? She has no answer. There was a litany of reasons. I mean, it's laid out more specifically in the brief.
Okay, hold on. Now, look at how he's trying to paint that to try to make it seem like it's a lie. She was raped in the car while the man in the vehicle, right? Then a tussle began to the point where she ended up jumping out of the car and one of her shoes is left. Then he said later on they go back to the crime scene and the shoe is 100 yards up somewhere else. How did her shoe get there? Because it's a shoe in traffic to some degree. Time later, anybody could throw a damn shoe. Any shoe could even get hit by another car to make it even go somewhere else. Somebody could come kicking the damn shoe. A boy could come and throw the damn shoe. Don't matter that the shoe ain't at the same place where the rape started at when it's out in public where life is going on and anything could come by and swipe it away, throw it, however. Like, how come the shoe is not where the rape was at? Why the shoe is 100 yards from where the rape took place? Like, you sound stupid. Like, that wasn't even, that was terrible. That was terrible. That was terrible.
Ms. Simeon on a known pandering website prior to submitting this request. She had taken Ms. Simeon in a vehicle back to the crime scene where this had happened. Ms. Simeon, in her interview, told the detective that this act occurred in the middle of the street. They go back to the abandoned house and
look, this is what I'm saying. What he not saying, the next day, the detective took Kiera to where the crime scene happened. The next day. So he asked him, he trying to be deceiving. He trying to make it seem like when she was raped, they took her back to the crime scene right then and there to actually see her shoe missing. The next day, they went back to the crime scene. So her shoe was out there for a whole day. And it was found in the bushes somewhere else. And he asked him, and he basically trying to be deceiving and try to make it seem as though it was the same day. He not saying it was the next day. They went back to the crime scene. And they ended up happening to find her shoe some yards away. Like, come on, what are you talking about? Terrible. Trying to be deceiving. That's what I mean. Like, trying to lie and be so deceiving, man, any lawyer tear him apart, boy. I'll tear this dude apart in the damn courtroom.
And they find her sandal 100 yards up in this driveway. The detective is asking her, how did this happen? How can you explain your sandal got here? She has no answer. There was a
Look, right. Look what he said. The detectives asked, how did your shoe get here? She has no answer. Right. I wouldn't have an answer. If I said the rape happened on 29th Street, then the next day you find my shoe on 30th. You like, how your shoe get on 30th? Yeah, I don't know. I know that it happened on 29th Street, and as a result of it happening on 29th Street, however, what happened the next day, anybody could have came past that shoe, kicked it along while walking, or picking it up and throwing it, that it ended up on 30th. I know yesterday it happened on 29th Street. See what I mean? Like, come on, like, stop it. That's stupid, foolish argument. That's crazy. Like these women stupid. These judge women ain't stupid.
litany of reasons. I mean, it's laid out more specifically in the brief, but there were a lot of reasons for the detective to doubt. From the first moment that she interviewed Simeon could not describe where she got the number. She couldn't state who she got it from. She couldn't identify where she was going. She didn't have money to pay for a cash taxi. You think someone needs cash to pay for a cash taxi? Didn't have that. It's just and that's the reason that she is investigating further, right? That's the reason that she's asking Michael Rucker for an interview. That's the reason that she waited 2 days to execute the search warrant. The statement in the ECR is, the analysis predicts he's going to rape again tonight.
Okay, so Quentin Davis says, I was just finna actually ban you, brother, but I said to myself, some of these dudes just tell. He said, Truth, you know the reason nobody rocking with you on this is because we all know he did it. Ain't nobody in the battle rap community doing nothing about it. Nothing about it. Stop talking about it and go get them if you this passionate. This is called awareness. And just because you don't care, other people don't care, who don't matter. It's other people in here who do care. You see, it's 300 people watching. All this stuff to try to make it seem like don't nobody care. You might not care. Other people care. And there's many people in your family who've been raped, who've been molested. And for you to be so insensitive of this really show the type of guy you is. How many people in your family been raped? How many people in your family been molested? What are you doing about it? Are you going after the person who may have raped your mama, your daughter, your niece, your cousins? When you make statements like this, are you not ignorant of what may be going on in your personal life and people in your life? So when you saying stupid stuff like this just to get attention in the comments, you sound crazy, bro. You sound crazy. So no, and don't tell me to stop talking about something like this, because that's the problem why things like this keep going on. People sweep it under the rug. They don't expose it. They don't bring awareness to it. And then they want you to just act as if, so what? No, it ain't so what. You don't have to like it. Look, when I put these titles up here, it tell you what I'm finna talk about. It's a breaking news, live footage of the Chris Unbias trial, watch party. So don't come in here complaining about it when you already see what it's about. If you don't want to hear it, you don't want to watch it, don't click on the link. Don't click on the video. That's what be so crazy about some of this stuff. You see what it says. If you don't want to hear about it, hey, go to another channel. Change the channel, go to something else. But it's obvious people want to hear about it. There's over 300 people up in here. So they want to hear about it. Come on, man. They want to hear about it. Q Thomas says, we care, Truth. I know. I know, but you know what I like? We now got faces to the paperwork. See, we ain't gonna listen to Chris no more. We got faces. We gonna watch the trial. We gonna watch the trial play out itself. We got the faces of the players involved now. Look at this lawyer. Look at Chris lawyer down here. He looked like Chubby Chase. He looked like dude from the what was they called? He looked like the fat man from Laurie and Harvey. What they called? Laurie and Harvey. And what's the dude's name? Dang, what's the dude's name? They wear the suits with the sunglasses and the hats. The Chicago, what was they? The Blue? What was their name? Dang, what was their name, man? What was their name? What was the two dudes' name? They dress up in the suits like Men in Black with the sunglasses. The Blues Brothers, right, Kishiro? Right. The Blues Brothers, right. Facts. Look, y'all know it. All I gotta do is say it. Y'all know it. Look, facts brief. He do look like dude from Kings and Queens. Facts.
She proffered that to the provider and then got the search warrant, but didn't do anything with it for 2 days. If you that undermines the entire premise of her proffered agency, is her failure to execute the search warrant. So there's a lot of objective circumstances in this case that showed that Detective Evans was not confident in her representation to the provider that these two allegations were linked. And the reasons were there were dubious inconsistencies associated with both. I heard...
And exactly, remind me of what was obtained by law enforcement from the exigent circumstances request. What was actually obtained?
48 hours of real-time GPS location data associated with Mr. Gunsby's cell phone.
Which resulted in law enforcement being able to do what?
Okay, look. Now, watch Chris Lawyer leave out everything that was found. He tried to always keep it sensitive to make it seem like it's no big deal. He ain't gonna mention nothing about the fake money, nothing about the gun, nothing about the butt plugs, nothing about the fake IDs, nothing about nothing. He just gonna say the cell phone. Listen.
Identify Mr. Gunsby's cell phone inside the address at 3875 Partridge Place in Rockdale County.
That resulted in the surveillance that counsel mentioned to us a moment ago.
Correct. And the attempt to then go to the Rockdale County magistrate judge. And this is where we drew the analogy to the Kylo case from the Supreme Court, where the Supreme Court condemns the practice of using high temperature sensing data to reveal intimate details from within the home. They say that's a search. In that case, it was flying a drone over a house to sense how much electricity is being used to find out that there's a marijuana operation inside the home. But this is the same thing here.
And then the ultimate search warrant resulted in the seizure of the cell phone of the alleged victim?
Yes, Your Honor.
And so then your argument to this court is based on what the public might refer to as a technicality, if you will. But if this court agrees with the trial court, then the cell phone that was obtained through the search warrant will be suppressed and not used as evidence, correct?
It's correct.
Which then I think results in your position that you want the court to consider reversing the trial court on the counts that would be, under your argument, dismissed against the defendant, correct?
Yes, the counts that we've challenged in the motion to dismiss are the counts that relate to the same victim whose phone was found within the house. That's true. So there's separate arguments to reach the same goal. But But I would not submit that this is a technicality. I would submit that this is an outright Fourth Amendment violation. I mean, in United States versus Leon, the Supreme Court created good faith exceptions, but it noted that where that does not apply is where law enforcement engages in misconduct, reckless disregard for the truth, and that is precisely what the trial court found. The trial court took a very big step here to reject wholeheartedly the credibility of this detective, and that factual finding, that credibility determination, is entitled to substantial deference. It's analyzed under the clearly erroneous standard. There's no doubt that there's facts to support that credibility rejection. And if you accept, as the trial court did, that Detective Evans acted in bad faith, did not act in good faith, or violating Franks, then you can't apply any good faith exception, which I'll note requires the good faith of both the applying officer and the subscriber, as quoted in the Swinson case that we've argued about in the briefs. I think I heard the state say in their argument that because this was decided because this search occurred pre-Carpenter, Mr. Gunsby had no reasonable expectation of privacy in his cell site data. That's not correct. We would maintain that the use of real-time GPS location data to basically track the location of someone's cell phone is the same thing as tracking movement to their car or their person, things that the Supreme Court of the United States has held implicate a search far before Carpenter, like in United States versus Jones. So this is a Fourth Amendment violation. It's not a technicality. It is true that the remaining search warrants are derivative of the Rockdale warrant, and that the affidavit in Rockdale County hinges upon the fruits of the ECR. So because the trial court is entitled to substantial deference, striking the statements that were submitted in the ECR and rejecting the credibility of the officer, whichever way the court were to go. If it were to hold that Franks applies, then the trial court's entitled to deference and the result should be affirmed. If the court accepts the state's invitation to go beyond the express language in the ECR and examine the objective circumstances before the officer, those factual findings are entitled to deference too. And there was plenty of evidence to cause Detective Evans to doubt the link between these two allegations before she submitted the request. And that's why there was not an exigency in this case.
Just out of curiosity, had the detective stated things in the ECR that were, in your mind, what would be more accurate or truthful or forthcoming? Is there anything in the record that would show if that would have changed the response by the third-party cell phone provider?
No, Your Honor. What we have in this record is the ECR as submitted and the results from that. But I think it's safe to say that if the Franks analysis is applied and the statements, the concededly inaccurate statements, because at the hearing on the motion to suppress, the detective admitted that everything she wrote was inaccurate. So it's really not even a dispute about whether it was accurate or whether it wasn't. Everyone agrees that what she wrote was wrong. But if those are stricken and the report says nothing, the ECR says nothing, then the provider would not be authorized to release in good faith otherwise protected information.
Talk a little bit about your cross appeal.
So after in the very beginning of this case, we placed the lead detective, Katrina Evans, and the district attorney's office and the statewide record service on notice that the vehicle that was towed from Mr. Gunsby's home was critical to Mr. Gunsby's defense and that it contained exculpatory evidence. In that letter, we asked them to release a law enforcement hold. We informed them that it was not abandoned. When the case was indicted, we filed a motion to preserve and inspect evidence. We attached that as an exhibit. When the case was re-indicted, we filed again. And the long and short of it was when we finally got the opportunity to go there with our expert to test the rear of this vehicle, it had been used as a garbage can. The back glass gate of the vehicle had been shattered, and there was dirt and garbage all throughout the vehicle. Everyone knew at all times relevant that this was, that it had a law enforcement hold on it, and the basis for the search, the analysis of the vehicles, everybody's looking for the same thing. The state is looking for biological material to corroborate the sexual allegation in the front of the vehicle, and we are looking for the same material in the back to corroborate our theory of the defense. We took Mr. Gardner there. He was unable to conduct an examination, and there was no other way other than for us to preserve our trial defense and to place them on notice that this was critically exculpatory evidence other than the way that we did that with the letters. The state took zero efforts to place this in special care.
They did allege that it took you 6 months to get out there or try to get out there. Is that an issue that weighs against you all?
No, Your Honor, I don't think so, because as long as the hold remained, we had to seek judicial approval to do that ex parte, which we did. And when we tried that, our efforts were thwarted because the record service and the investigator, may I finish the answer, Your Honor?
Yes, please.
The record service and the investigator for the district attorney's office did not honor the trial court's ex parte order. So then we had to have a contempt hearing and do it all again. And then 6 months after that, we went out a second time, and that's when we discovered the vehicle was broken.
All right. And so for that reason, you're saying that those counts 4, 5, and 6 should be stricken?
It should be, because the state was on express, unequivocal notice that there was exculpatory exculpatory evidence in that vehicle, and that it was critical to our defense. And there were no steps taken to take care of it.
Thank you.
Briefly, Your Honor, picking up where opposing counsel left off, I want to point out that I think it was actually 17 months from the date the vehicle was seized until the time they first went out in January of 19 to try to get access to the vehicle. They knew the vehicle was outside. They knew what was at. They said the evidence is exculpatory, but never identified the nature of that evidence, and never asked the state to take any special care.
But you're talking about the vehicle where the rapes are alleged to have occurred, the rape and the sexual assault. This is like the room where it happened. So like the idea that it's basically taken to what seems like not a very good location to try to store something to maintain it from either the prosecution or their side gives me a little pause. And the question I had in your brief is, you say it's not readily apparent, and I got the impression you were saying that in your brief because you can't see this kind of cells and things that you're pulling at the back. But that's not what readily apparent means. You have to be able to visually see something to know that it's important. It's the idea that you readily know that there could be evidence in that vehicle, whether you can see it or not, that could be potentially exculpatory. Do they have to like literally write it out for you and give you every bit of their defense? Or is just the idea that the rape's supposed to occur here? We want to be able to look at it.
Well,
And that's a lot of questioning in there. So I'll give you an opportunity
with
to wrap
permission.
up.
Thank you, Your Honor. With respect, the term readily apparent literally means visible. That's both case law and the dictionary understanding of the word. It has to be a thing the state would be aware that it's exculpatory before it can be destroyed. And then the destruction certainly is not ideal. I will grant you that. But the vehicle was stored pursuant to the county policy. And generally when you follow county policy or police policy, that's not the same thing as intentional destruction, which is the bad faith part of this analysis. And the fact that you identified, first of all, they identified 4 or 5 different things that were, quote, exculpatory and never described the nature of it. Had they taken any steps to identify the quality of the information, or the quality of exculpatory information, or even asked to see the vehicle, all they did was ask to hold it, then we'd be in a different situation. There has to be some element of obligation on the defendant to exercise his due process rights in a timely manner. Otherwise, he's sitting on his rights, waiting for some sort of problem to occur, and then to complain about his failure to act in a prompt and timely fashion.
Right. Thank you.
May I ask one thing?
Yeah.
If this was such an emergency, also the state limited its evidence collection to the front seat. If the state thought this was a serial rapist, why was the evidence collection limited to just the front seat?
Well, because the state only knew about 2 cases. They knew about 2 alleged victims, Miss Simeon and Miss Hill, each of whom alleged that the assault happened in the front seat. So the focus was on the front seat in terms of collecting trace evidence. They did examine the entire vehicle, but didn't take lifts or prints or anything in the back. They had no reason to do so because they had no evidence to suggest there'd ever been a crime in the back of that large SUV. Any other questions from the court? Thank you for your time. Thank you.
Thank you.
And there you have it. So that right there is why that's the appeal. So that's what they was arguing. That was the appeal for. So trial was put on hold till the appeal was actually cleared on whether or not they were going to allow the evidence, some of the evidence that was thrown out, to be reinstated back in before trial. That's what we at right now on his trial. We right here at his trial. And this is why just recently, last week, his house got raided and they had a search warrant for his mouth to get, I guess they want an up-to-date of his DNA just before trial, since it's been going on for so many years, even though they already have it in his record. I guess they just want to do it again, especially when you see the argument they were doing about the detective, you know. So so trial is underway. It's here. He know it. He know it. And I know y'all like, man, it's been going on for a minute. But these things take time like that, especially when you got a guy who literally accused of raping 4 different women. So yes, it's going to be a long time. When one woman is raped, it take a long time. How much more 4? You know, so it is what it is though. But there you go, man. There you have it right there. With that being said, it's your boy Battle Truth. It ain't my judgment, that's a question. It's yours.